Your post-graduation work permit application has been refused. The cause isn't a complex legal violation or a background check failure. It's a missing language score, a single PDF that wasn't attached to the original submission. The moment that refusal letter is issued, maintained status expires. You are no longer authorized to remain in Canada under your previous student permit conditions. You must stop working immediately. Continuing employment after a refusal constitutes unauthorized work, which can disqualify you from all future immigration pathways. This delay has a secondary, terminal consequence. Because the government took months to process the application before refusing it, the 180-day window to apply for a PGWP has already passed. You have lost your right to work, your valid status, and the standard legal window to fix the error, all because of one missing document. Most applicants react to this crisis by attempting one of two immediate self-guided fixes. Many attempt a web form reconsideration request, sending the missing language score to the IRCC and asking for the decision to be reversed. Reconsideration is a tool for correcting officer errors. If the document was missing at the time of the decision, the refusal was legally sound, and the request will be denied. Others apply for a visitor record to restore their status, believing that legalizing their physical presence is the first step toward a new work permit. As we will see when we examine the legal mechanics, a visitor record addresses your presence in Canada while leaving the underlying work permit eligibility problem untouched. Treating a hard statutory deadline as a minor administrative typo often results in a second, permanent refusal. Navigating this crisis requires isolating two distinct legal concepts: status and eligibility. Status is your right to be physically present in Canada. It governs where you can stand, not what you can do. This diagram separates them. Status is a binary state of presence. Eligibility is a time-bound requirement. You must satisfy both. A visitor restoration fixes status, granting a legal stay. But the 180-day eligibility clock continues. Once expired, visitor status cannot reset it. Canadian immigration law does not grant visitors the right to apply for a post-graduation work permit if the statutory window has closed. The visitor record secures your presence as a tourist, but leaves you legally ineligible to work. Only one legal instrument can bypass the 180-day eligibility requirement: the Temporary Resident Permit, or TRP. A TRP is a standalone category, independent from student permits, independent from work visas, and independent from visitor authorizations. It functions as an exceptional grant of stay for individuals who are otherwise inadmissible or lack a valid basis for a standard visa. Within the TRP framework lies a specific provision that overrides standard work permit restrictions. Filing a TRP valid for 6 months or longer, the holder gains legal authorization to apply for a work permit from within Canada. This override resets eligibility criteria, allowing the application to proceed despite the 180-day window closing. The TRP creates a new legal bridge, allowing the applicant to move forward based on a statutory exception rather than a standard deadline. Filing a TRP after the fact or as a standalone request usually leads to rejection. Specialized Immigration Counsel utilizes a strategy called concurrent filing to ensure the officer sees the entire legal context at once. This strategy requires pushing 3 applications into the portal at the same time: the restoration of status, the TRP request, and the new PGWP application. The TRP acts as the structural foundation. The officer must evaluate the exception first to create the legal authority to approve the work permit. Without the TRP acting as the anchor in this bundle, the automated system would see only a late PGWP application and trigger an immediate refusal. This architecture forces a human officer to engage with the legal argument before the system can issue an algorithmic rejection. The document that justifies this entire strategy is the Letter of Explanation, or LOE. The LOE functions as a legal brief, requiring specific evidentiary standards to support a request for discretionary relief. It must first provide objective evidence, such as a dated test receipt, proving that the applicant met the educational requirements before the original deadline expired. The letter then addresses humanitarian and compassionate grounds, detailing why the loss of a career path over a technical error is a disproportionately harsh outcome. Finally, it presents an economic argument, demonstrating the applicant's value to the Canadian labor market and the national interest. The LOE provides the officer with the necessary legal justification to exercise their extraordinary power to bypass the standard rules. TRP approvals are never guaranteed. They rely entirely on the discretion of an individual officer who must be convinced your case warrants an exception. The process involves a separate $200 fee and subjects you to significantly longer processing times than a standard permit. You must remain in Canada without the ability to earn income while the government reviews the case. If the TRP is denied, the entire concurrent package fails, and the refusal of your PGWPG becomes final. This is a high-stakes legal maneuver, utilized only when all standard avenues have been exhausted. Solving a 180-day refusal requires a shift from administrative filing to statutory arguments. If you are in this position, do not attempt to file a concurrent TRP package on your own. You require an RCIC or a specialized immigration lawyer to build the evidentiary record and draft the legal arguments. Immigration agencies should identify these cases immediately as complex legal disputes rather than routine paperwork. Understanding the technical distinction between basic presence and the statutory power of a TRP determines whether an applicant faces a permanent refusal or a successful recovery of their status.